This is part 52, and in this part we shall be dealing with chapter 8, which deals with offences against public tranquility. And the first section, we will start right from section 141 and go up to section 160, but section 141 defines unlawful assembly. What is unlawful assembly? And it says, an assembly of 5 or more persons is designated an unlawful assembly if the common object of the persons composing that assembly is. In other words, in order to understand unlawful assembly, you have to remember 5 figure 2 times. 5 or more persons assembled together. There is an assembly of 5 or more persons, and they assemble together with any one of the 5 objects which are enumerated as far as section 141 is concerned. It says, first, to overawe by criminal force or show of criminal force the central or any state government or parliament or the legislature of any state or any public servant in the exercise of the lawful power of such public servant. Second, to resist the execution of any law or of any legal process. Thirdly, to commit any mischief or criminal trespass or other offense. Fourth, by means of criminal force or show of criminal force to any person, to take or obtain possession of any property or to deprive any person of the enjoyment of right of way or of the use of water or other incorporeal right of which he is in possession or enjoyment, or to enforce any right or supposed right. Fifth, by means of criminal force or show of criminal force to compel any person to do what he is not legally bound to do or omit to do what he is legally entitled to do. And the explanation to the section clearly lays down, an assembly which was not unlawful when it assembled may subsequently become an unlawful assembly. An assembly which was not unlawful when it assembled may subsequently become an unlawful assembly. If 1,000 persons go to some government office in a procession, they have taken permission and they proceed to press for their demands with the government, maybe collector. Then there are 5 or more persons, but they do not come together or assemble together with any one of the 5 objects. But when they reach there and they are asked to leave the place and they do not leave the place, the assembly, which was not lawful right in the beginning, now they are there to resist the execution of law or any legal process, and hence the assembly, which was not unlawful when it assembled, may subsequently become an unlawful assembly. So that is as far as section. And then the sections, as you go read the 5 objects with which they come together. So merely coming together of 5 or more persons with any one of the 5 objects which are enumerated as far as section 141 is concerned constitutes what is known as an unlawful assembly. And then section 142 makes mention of being member of unlawful assembly and says, whoever being aware of the facts which render any assembly an unlawful assembly intentionally joins that assembly or continues in it is said to be member of an unlawful assembly. So who is member of an unlawful assembly is defined as far as section 142 is concerned. Section 143, whoever is a member of an unlawful assembly shall be punished with imprisonment of either description for term which may extend to 6 months or with fine or with both. Being member of an unlawful assembly is made punishable as far as section 143 is concerned. Section 144, joining unlawful assembly armed with deadly weapon. And it says, whoever being armed with any deadly weapon or with anything which used as a weapon of offense is likely to cause death is a member of an unlawful assembly shall be punished with imprisonment of either description for term which may extend to 2 years or with fine or with both. And then section 145, joining or continuing in unlawful assembly, knowing it has been commanded to disperse. And it says, whoever joins or continues in an unlawful assembly, knowing that such unlawful assembly has been commanded in the manner prescribed by law to disperse, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. With this now, we try to understand what is rioting. Rioting is an aggravated form of unlawful assembly, because it says section 146 defines rioting, and it says whenever force or violence is used by an unlawful assembly or any member thereof in the prosecution of the common object of such assembly, every member of such assembly is guilty of the offense of rioting. So that is section 146. Whenever force as it is defined by section 349. Violence is nowhere defined. So, you have to understand, you refer to General Clauses Act of 1897, you won't find out. So, you have to, refer to the standard dictionary for the purpose of knowing the meaning of the term violence. But whenever force or violence is used by an unlawful assembly or any member thereof in the prosecution of common object of such assembly, every member of such assembly is guilty of the offense of rioting. So rioting is equal to unlawful assembly plus when force or violence is used by an unlawful assembly or any member thereof constitutes what is known as rioting as defined by section 146. And then section 147 lays down punishment, which says whoever is guilty of rioting shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. And then section 148 says rioting armed with deadly weapon. Whoever is guilty of rioting being armed with deadly weapon or with anything which used as a weapon of offense is likely to cause death shall be punished with imprisonment of either description for term which may extend to 3 years, or with fine, or with both. With this now, we try to understand what is common object as it is dealt by section 149. And in order to understand section 149, imagine a situation where 1000 persons went to the collector's office for the purpose of pressing their demands with the collector. When they were at a distance of 500 meters, they were stopped by the police and they were not allowed. All of them wanted to go and meet the collector, but the police said, from the point of view of law, peace and order and security, all of you cannot be allowed to enter the collector's office. Only your few representatives shall be allowed. And all of them claim that in democracy nobody is a representative leader and nobody is follower, everybody is leader. So all of us, we want to go, and that was not allowed. So when they were standing there, they started to use a force by breaking police cordon in order to get into the collector's office. They were stopped, and then they were ordered to disperse. As soon as they are ordered to disperse, there is oral order, and they continue their stay over there. They continue their presence over there. They do not disperse. They constitute unlawful assembly as section 141 is concerned. Now, out of these after some time, out of these 1,900 left away. They said, as we are asked by the police to go away, we must go, otherwise, this will create many problems. So they left the place. But then 100 remained there. They had 10 groups, and each consisting of 10 groups, and they started dashing against the police cordon. 9 groups could not serve the purpose. The 10 group could succeed. But then when he was obstructed by the one of A was obstructed, who was member of the last group, he was obstructed by the police officer. He took his stick and gave blow to the police officer and committed the offense of voluntarily causing hurt, defined by section 321 of the Indian Penal Code. Who is liable? As far as this offense of voluntarily causing hurt is concerned, which is defined by section 321, whether Mr. A only is liable or 10 rest of the 9 persons along with him are also liable as far as that batch was concerned, or 100 persons are liable, or 1000 persons are liable, is the question for our consideration. And then if you read section 149, which says every member of unlawful assembly guilty of offence committed in prosecution of common object. And it says if an offence is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members that assembly knew to be likely to be committed in the prosecution of that object, every person who at the time of the committing of that offence is a member of the same assembly is guilty of that offence. So section 149 deals with what? It deals with what do you mean by common object. 1000 persons were there, but then how many remained there? 100. So the question of liability of 900 persons who left doesn't arise. Now those who were members, 100 were members. So if A has given a blow to the police constable with the help of the stick, rest of the 99 are also charged or also liable for the offence of voluntarily causing hurt, because if the offence is committed by any member of an unlawful assembly in the prosecution of common object at that assembly, such as the members of the assembly knew to be likely to be committed in the prosecution of that object, every person who at the time of committing of that offence is a member of same assembly is guilty of that offence. And then during course of time, when we dealt with constructive liability or vicarious liability, this is the time for me to draw your attention to the illustrations. And what was that illustration? A, B, C and D decided to go and kill Mr. Z. And then A said, I will fire into direction of Mr. Z, no problem. Mr. B, you should stand in the door. Mr. C, you should stand in the gate. And Mr. D, you should sit in the car. And as soon as I commit the murder, we will all run away. And accordingly, the murder was committed. What is their liability? Now, if you want to know their liability is dealt by section 34 of the Indian Penal Code. And what is section 34 of the Indian Penal Code? It says, when a criminal act is done by several persons in furtherance of common intention of all, each one of them is liable for that act in the same manner as if it were done by him alone. This explains the principle of our constructive liability. As far as the common intention is concerned, each one of them is liable. In case of common intention, as we have learned, there is prior meeting of the minds. There is presence of the offender at the scene of the offence and participation of the offender as far as commission of an act which amounts to an offence is concerned. So this is what is known as common object, whereas, this is known as common intention. But in case of common object, if they assemble together with one of the 5 objects that are enumerated as far as section 141 is concerned, and if the criminal act is done by one of the members of an unlawful assembly, and how he has done, if that act is done in the prosecution of the common object of such assembly, or such as the members of the assembly knew to be likely to be committed in the prosecution of that object, then every person who at the time of committing of that offence is member of same assembly is guilty of that offence as per section 100, liabilities as per section 149 of the Indian Penal Code. With this, if you read section 159, which defines the offence of affray, and it says, when 2 or more persons by fighting in a public place disturb the public peace, they are said to commit an affray. So what is an affray? 2 or more persons by fighting in a public place disturb the public peace. Mere quarrel? No. There must be exchange of blows, and they must fight. If one beats and other is just very non-violent follower of doesn't do anything. In that case, for example, that is not a fight. Fight is exchange of blows. So when 2 or more persons by fighting in a public place disturb the public peace, they are said to commit affray as per section 159 of the Indian Penal Code is concerned. And then if you read section 160, which says punishment for committing affray, and it says whoever commits an affray shall be punished with imprisonment of either description for term which may extend to 1 month, or with fine which may extend to 100 rupees, or with both. With this now, let us finish with the rest of the sections dealing with punishment. Section 150, hiring or conniving at hiring of persons to join unlawful assembly. And it says, whoever hires or engages or employs or promotes or connives at the hiring, engagement or employment of any person to join or become a member of any unlawful assembly shall be punishable as a member of such assembly, and for any offence which may be committed by any such person as a member of such assembly in pursuance of such hiring, engagement or employment in the same manner as if he had been a member of such unlawful assembly or himself had committed such offence. So that is dealt as far as section 150 is concerned. Section 151, knowingly joining or continuing in assembly of 5 or more persons after it has been commanded to disperse. And section 151, it says, whoever knowingly joins or continues in any assembly of 5 or more persons likely to cause a disturbance of the public peace after such assembly has been lawfully commanded to disperse shall be punished with imprisonment of either description for term which may extend to 6 months, or with fine, or with both. And the explanation says, if the assembly is an unlawful assembly within the meaning of section 141, the offender will be punishable under section 145. 152 says, assaulting or obstructing public servant when suppressing riots, etc. And it says, whoever assaults or threatens to assault or obstructs or attempts to obstruct any public servant in the discharge of his duty as such public servant, in endeavoring to disperse an unlawful assembly or to suppress a riot or affray, or uses or threatens or attempts to use criminal force to such public servant, shall be punished with imprisonment of either description for term which may extend to 3 years, or with fine, or with both. Section 153. Wantonly giving provocation with intent to cause riot, if rioting be committed, if not committed. Now it says, whoever malignantly or wantonly, by doing anything which is illegal, gives provocation to any person intending or knowing it to be likely that such provocation will cause the offence of rioting to be committed, shall, if the offence of rioting be committed in consequence of such provocation, be punished with imprisonment of either description for term which may extend to 1 year, or with fine, or with both. And if the offence of rioting be not committed, with imprisonment of either description for term which may extend to 6 months, or with fine, or with both. With this, section 153 defines offence of promoting enmity between different groups on the ground of religion, race, place of birth, residence, language, etc., and doing acts prejudicial to maintenance of harmony. Says, whoever, a, small a, by words either spoken or written, or by signs or by visible representations, or otherwise promotes or attempts to promote on the ground of religion, race, place of birth, residence, language, caste, community, or any other ground whatsoever, disharmony or feeling of enmity, hatred, or ill will between different religious, racial, language, or regional group, or caste, or communities, or small b, commits any act which is prejudicial to the maintenance of harmony between different religious, racial, language, or regional groups, or caste, or communities, and which disturbs or is likely to disturb the public tranquility. Small c, or organizes any exercise, movement, drill, or other similar activity intending that the participant in such activity shall use or be trained to use criminal force or violence, or knowing it to be likely that the participant in such activity will use or be trained to use criminal force or violence, or participates in such activity intending to use or be trained to use criminal force or violence, or knowing it to be likely that the participants in such activity will use or be trained to use criminal force or violence against any religious, racial, language or regional group or caste or community, and such activity for any reason whatsoever causes or is likely to cause fear or alarm or feeling of insecurity amongst members of such religious, racial, language or regional group or caste community, shall be punished with imprisonment which may extend to 3 years, or with fine, or with both. Now, further part says, offences committed in place of worship, etc. and says, whoever commits an offence specified in subsection 1 in any place of worship or in any assembly engaged in the performance of religious worship or religious ceremonies shall be punished with imprisonment which may extend to 5 years and shall also be liable to fine. With this, section 153, capital AA, punishment for knowingly carrying arms in any procession or organizing or holding or taking part in any mass drill or mass training with arms. Whoever, and the section says whoever, knowingly carries arms in any procession or organizes or holds or takes part in any mass drill or mass training with arms in any public place in contravention of public notice or order issued or made under section 144A of the Criminal Procedure Code 1973 shall be punished with imprisonment for a term which may extend to 6 months and with fine which may extend to 2,000 rupees. Explanation says arms means articles of any description designed or adapted as weapon for the offense or defense, and includes firearms, sharp-edged weapons, lathis, dandas and sticks. Section 153B, capital B, imputations, assertions prejudicial to national integration, and it says whoever by words of either spoken or written or by signs or by visible representations or otherwise, small a, makes or publishes any imputation that any class of persons cannot, by the reason of their being members of any religious, racial, language or religional group or caste or community, bear true faith and allegiance to the Constitution of India as by law established, or uphold the sovereignty and integrity of India, or B, small b, asserts, consents, advises, propagates or publishes that any class of persons shall, by reason of their being members of any religious, racial, language or regional group or caste or community, be denied or deprived of their rights as citizen of India, or small c, makes or publishes any assertion, counsel, plea or appeal concerning the obligation of any class of person by reason of their being members of any religious, racial, language or religious group or caste or community, and such assertion, counsel, plea or appeal causes or is likely to cause disharmony or feeling of enmity or hatred or ill will between such members and other persons, shall be punished with imprisonment which may extend to 3 years, or with fine, or with both. Subclause 2. Whoever commits an offence specified in subsection 1 in any place of worship or any assembly engaged in the performance of religious worship or religious ceremonies shall be punished with imprisonment which may extend to 5 years and shall also be liable to fine. Section 154. Owner or occupier of a land on which an unlawful assembly is held, and it says whenever any unlawful assembly or riot takes place, the owner or occupier of the land upon which such unlawful assembly is held or such riot is committed, and any person having or claiming an interest in such land shall be punishable with fine not exceeding 1,000 rupees if he or his agent or manager, knowingly that such offence is being or has been committed, or having reason to believe that it is likely to be committed, do not give the earliest notice thereof in his or their power to the principal officer of the nearest police station, and do not, in a case of his or their having reason to believe that it was about to be committed, use all lawful means in his or their power to prevent it, and in the event of its taking place, do not use all lawful means in his or their power to disperse or suppress the riot or unlawful assembly. Section 155. Liability of person for whose benefit riot is committed. And section it reads, whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which riot takes place, or who claims any interest in such land, or in the subject of any dispute which gave rise to the riot, or who has accepted or deprived any benefit therefrom, such person shall be punishable with fine, if he or his agent or manager, having reason to believe that such riot was likely to be committed, or the unlawful assembly by which such riot was committed was likely to be held, shall not respectively use all lawful means in his or their power to prevent such assembly or riot from taking place, and for suppressing and dispersing the same. Section 156. Liability of agent of owner or occupier for whose benefit riot is committed. And it says, whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which such riot takes place, or who claims any interest in such land, or in the subject of any dispute which gave rise to the riot, or who has accepted or deprived any benefit therefrom, the agent or manager of such person shall be punishable with fine, if such agent or manager, having reason to believe that such riot was likely to be committed, or that the unlawful assembly by which such riot was committed was likely to be held, shall not use all lawful means in his power to prevent such riot or assembly from taking place, and for suppressing and dispersing the same. 157. Harboring persons hired for an unlawful assembly. And says, whoever harbors, receives or assembles in any house or premises in his occupation or charge or under his control any person, knowing that this person has been hired, engaged, employed, or are about to be hired, engaged, or employed to join or become members of an unlawful assembly, shall be punished with imprisonment of either discretion for term which may extend to 6 months, or with fine, or with both. With this, section 158. Being hired to take part in an unlawful assembly or riot. And says, whoever is engaged or hired, or offers or attempts to be hired, or engaged to do or assist in doing any of the acts specified in section 141, shall be punished with imprisonment of either description for term which may extend to 6 months, or with fine, or with both. Or to go armed, and whoever being so engaged or hired as aforesaid goes armed, or engages or offers to go armed with any deadly weapon, or with anything which used as a weapon of offence is likely to cause death, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. With this, section 159 we have already dealt, defines the offence of affray, which says, when 2 or more persons by fighting in a public place disturb the public peace, they are said to commit an affray. And section 160 lays down punishment for committing affray. So now in the next part we shall start discussing right from section 161 up to section 170, which deals with offences relating to public servant. And as soon as we finish with offences relating to public servant, we will immediately start right from section 171 capital A up to 171 capital I in order to know offences relating to election.